Good evening, everyone, and welcome back to the fifth instalment of the Whistleblower Diaries. I'm Nevena, the General Manager of the Information Rights Project. Thank you very much for being here with us tonight. The Whistleblower Diaries series exists for one reason, and that's to hear directly from people who have told the truth and paid for it. Tonight, we have a person with us. Bernard Cleary is a Canberra barrister and the former Attorney General of the ACT. In 2013, he took on a client the government did not want heard. I'm sure many of us here tonight will be familiar with Witness K, a former ASIS officer, had blown the whistle on Australian alleged bugging of Timor-Leste's cabinet room. The operation ran during negotiations over billions of dollars in oil and gas. For representing Witness K, the Commonwealth then charged Bernard in 2018 under the Intelligence Services Act. He faced a secret trial for defending a whistleblower. The prosecution dragged on for 4 years, and much of it was shielded from public view and then discontinued in July 2022. This case exposed just how far the state will go to protect itself and just how fragile a fair and open trial can become. Tonight, Bernard Cleary will speak with us about this experience and what it means for the rest of us. As usual, we'll be in conversation with Bernard for about 40 minutes, and then we'll welcome your questions at the end via the chat or via the Q&A function. But firstly, Bernard Cleary, welcome to the Whistleblower Diaries.
Yeah, good evening, Nevena.
So long before Witness K, you did spend decades standing with the people of Timor-Leste through their independence in 2002. I'll be interested to know what drew you to them and what kept you there.
Oh, well, you got straight to the point. In the late 1960s, I did some special training with an Australian intelligence agency, and one of our trainers spoke glowingly of the Timorese who had aided our Australian soldiers behind the lines during World War II. I didn't even know where the Portuguese Timor was, and I'd never looked it up on a map for a long time. But when I was in Paris for about 5 years, the Whitlam government made those decisions that resulted in the Indonesian government taking over Timor, and I was pretty ashamed of what our role was in that. And I recalled what our instructor way back in the 60s had told us about the support of the commandos behind the lines. So that led me to decide, when I left the Australian government service, to assist the Timorese. So when I came back in 79, 80 to Australia, I got in touch with the diaspora in Australia and began assisting them with positive support for their independent struggle. So that went on for another 20, 30 years. But I came into it out of respect for the Timorese, who alone as a population in Southeast Asia stood and supported the former colonial sort of concept, and they supported the Australians. They were a Christianized population, and that had a role in it. But it's a long story.
So take us back to that time. That was a fair while ago. Have you seen much difference in the development since that time, since you've been back and forth?
Oh, yes. I mean, Timor's come out of a post-colonial struggle and an invasion. I mean, the country was racked by poverty, famine. Up to 200,000 people are estimated to have died during the invasion period. The islands are not particularly fertile. it has a creation myth, which is quite interesting. And all of those of us who've been up in the Arnhem Land and seen the wonderful paintings by people who could never have gone up in a balloon or a helicopter and faithfully replicated the patterns. But if you're in the cockpit of an aircraft approaching the island of Timor, you'll understand why their creation myth is that it was grandfather crocodile coming up out of the sea, because East and West Timor look from the air at a distance like a crocodile in the ocean. You've got the razor-backed mountains and the snout up at Com and the tail towards the end. And there's such a graphic history of Timor in the European exploration of the Southern Hemisphere. The Dutch, the Portuguese, latterly the French, and even latterly the British. And in Banjo Patterson's Man from Snowy River, he's riding a Timor pony. So we used to bring ponies in from Timor, the little mountain ponies in the 19th century. So there's been this long abiding connection between Timor and Australia, cemented during World War II, and sadly and treacherously exploited in the 80s and 90s by Australia.
And so following that, you began your working life as a diplomat, first secretary at the Australian Embassy in Paris. What pulled you from diplomacy and then into law?
Well, I was a lawyer before I went to Paris, and I left the service and came back to Australia and commenced practice in Canberra. Our children had gone to French schools. They'd been immersed. We didn't live in Paris. We lived in a French village quite away from out of Paris. And so our children came back as francophone, and Canberra it had to be because there was a French connection here, French school. And I found myself a lowly solicitor at the age of 35 or so, starting to practice law, and soon in touch with the Timorese, refugees generally, the West Papuans, and so forth. I had grown up. Our farm near Wollongong on the Illawarra at Fairy Meadow had been resumed when I was an infant for a migrant hostel. So I went to school with droves of refugee children and different languages, sandwiches without butter, lumps of cheese. So I've always had a good migrant refugee law practice.
And so some of you just painted the picture there with your connection to migrants and refugees, and some of your earlier cases were with refugees, West Papuans in the federal court and Vietnamese boat people. What did representing people with nothing teach you about the power of law?
It's only through law that we can evade what is happening now in our democracies. It's only, and it's sort of the pontoon or the plank that you'd grab as the ship sinks. Populist Trumpian America is a classic example of how vital the law is. In that case, the Supreme Court's been stacked to a certain degree, and you can see how the rule of law is suffering in the United States. It's vital that we not go, as we go a lot of other ways with the United States. It's vital that the law remains a bulwark Our High Court remains untainted, and our federal courts and our state courts, and particularly state courts exercising federal jurisdiction, all remain unstacked, and that judicial appointments stay on a merit quality base. So we're at a fine edge in Australia. We could go the US Trumpian way very easily because out there's an almost general despair and acceptance, not just a treatment of whistleblowers, an acceptance that government is a sort of process that rorts the people, and it's full of people who are self-helping. And so where else will you go if things get on the slide here but to our courts? So the law is very important, and I've perceived that. I recall being up on Thursday Island with West Papuan refugees. One or two had bayonet wounds and were being treated in the Thursday Island hospital. And I'll always remember a federal government minister referring to the West Papuan refugees on Thursday Island as, quote, black canoe paddling of job seekers. I'll never forget that Labor minister using those words, and I couldn't get my refugees off Thursday Island to get them into the federal court in Brisbane because for some reason the Bush Airways could no longer carry passengers, etc., etc., etc. That was at a fairly grim time in Australia's history, and if we don't represent the downtrodden, and if we don't support those who speak the truth to power and corrupt power at that, we'll go the Trumpian way. And we're at a turn point in Australia now on that, in my view.
You served as the ACT's Attorney General, and part of that drove law reform, including the Discrimination Act. Did sitting inside government change how you saw the state, how the state would be later when you faced them in court?
Oh, I couldn't believe it. I remember, I remember a week after we had government, and I was leading what you call now a teal group. We got as many seats as the Liberals and one less than Labor, and it was Graham Richardson's Labor, so there was not going to be any alliance there. So we joined with the small L Liberals, I must say they were, and we formed government. And a week later, the Federal Attorney General, Lionel Bowen, rang me and said, well, good on you. You're going to keep everyone honest, I hope. My landlady voted for you. Now, there's a meeting of all of Australia's Attorney Generals in Adelaide next week. I bet you haven't been told about it by your public servants. I said, no. He said, well, come out and meet me at my little plane on next Monday morning and we'll fly down to Adelaide. I got in the plane and he said, he kept calling me Bernie, and I'd say Bernard. But anyway, he said, Bernie, I'll wager you $5 that within half an hour someone mentions mud brick houses. I said, oh, well, yeah, okay, $5 we're on. I was sitting opposite a little table in his VIP plane. We arrived in Adelaide into this beautiful North Terrace colonial chandeliered building, and the only Attorney General I knew there was John Dowd because we were in the International Commission of Jurists together. Didn't know anyone else. And Lionel Bowen said, well, the first thing we've got to discuss is the murder of family court judges, all this nonsense about them just dressing as in normal clothes. We've got to re-robe them, etc. And Lionel had told me not to speak and just listen and learn. And he said, now, he passed the discussion to the Victorian Attorney General, who was a very pleasant, bearded schoolteacher. He wasn't a lawyer. And he said, well, I don't know why there's so much family disorder. We're going to redevelop our closed railway corridors, and I don't care if they build mud brick houses. And Lionel said, $5, Bernie. That was my opening to how our federation is run. But often on topics, the Labor and Liberal people would meet and caucus without me because I was the only non-Labor or Liberal Attorney General in the country. Um, and I realised that the major parties have shared interests, and at the end of the day, inevitably, like sovereign countries, the major parties go always with the shared interest. And I was embarrassed sometimes when they were all at breakfast together and I wasn't included. So this country needs to restate the political order. It's great to see, I'll be very frank about this, it's great to see the Teals, the community independence people rising in the parliament. In the end of the day, we were defeated in Canberra. We were political amateurs and we meant well, but we didn't have that. None of us were careerists. My deputy was a ex uh, Vietnam infantry captain. I had a reader in history and a Quaker as my third member, and another activist, Michael, in our party. We perhaps shouldn't have gone into government, but the Democrats wiped themselves out by thinking you could stay on the sidelines to keep, quote, the bastards honest. Uh, I My experience as Attorney General taught me how difficult the role was, how important it was to take prosecution decisions away from those who hunt down criminals, the variety of reasons, and we established the independent directorship of prosecutions here and did all sorts of. We were the first government in Australia to legalise prostitution and regulate it. We pioneered methadone clinics when the forces were against it in the rest of the country. So, like Dunstan, South Australia, there was a breath of fresh air here just after self-government when a group of us who sought reform managed to bring about reform. But I think the only way we'll get reform in this country now is for the rise of people who listen to stories, Nev, like you're running this evening, community consciousness about it. And I'm all for the more, what's her name? Pauline Hanson gets herself in front of the National Press Club, the better. And let's everyone see what is on to offer. And so I'm not looking for a turn in any way to the Hansonite right, but community independence, fine.
I'm sure you'll be quite relieved at the change of the political landscape over the last 30 years, with not only the growing crossbench, but the event of independent parties and micro parties, and then just broadening out democracy, especially down here in Victoria. We have a very unique political setup in our upper house with group voting tickets. So much like you, I very much
Your
stand
Fiona
for.
Pat in your upper house there helped me get my prostitution bills through the Parliament here, and she
I
went
used to
on.
work with Fiona.
She she went on to great things down there. No, there are some great people in our midst who could deliver the goods, but we need to deal with the maverick media and all those power groups.
And so that brings us to Witness K. You defended Witness K knowing what it might cost you. When did you understand that you had become the target?
Uh, well, I spent nearly 2 years on research with my officer course, determining whether uh, the alleged espionage could have been lawful. I mean, what the Australian public don't appreciate is that the alleged espionage would have been totally unlawful because the Intelligence Services Act required the operations of ASIS to be proper and lawful. But above all of that, the Bill of Rights, which is still law partly in this country and is emphasised frequently by the High Court. The Bill of Rights requires everyone in this country, minister or not, to observe the statute law of this country. When Australia agreed to join the Timorese in a joint petroleum venture, they wanted to be trusted, and they passed a bill in the Parliament. Alexander Downer introduced it, the Petroleum Timor-Sea Act 2003. That act wasn't just aspirational, it declared that Australia would negotiate aspects of the petroleum revenue arrangement in, quote, good faith. That was in the Timor Sea Treaty, of course, but treaties don't automatically become law. But to give legislative power to that treaty provision, Australia introduced a law that provided that negotiations would be conducted expeditiously and in good faith. And that wasn't an aspirational thing, it was the law. And so it was that law that the alleged espionage had to be matched to. And I concluded that the operation was maverick, was never, ever an intelligence operation. It was an alleged operation that was maverick. And that maverick activity had breached the law, was unlawful. And no one can breach statute law in this country. No cabinet, no minister, no ordinary citizen can break the law. So that was a conclusion reached after quite a bit of research. And so the alleged espionage represented not what the public believe, a sort of expose of our intelligence service in operation. It was never an intelligence operation. It was never lawfully approved. It couldn't be. And if it had taken place, and that's a conclusion that the courts won't allow me to say, it would have been utterly unlawful. Your lawyers listening could find the now appealed and amended Petroleum Timor-Sea Treaty Act 2003 and read those lines together with Article 9B of the treaty. So my view was if the alleged espionage had taken place, it was totally unlawful, and therefore no one could be charged with any offence. And I was confident that we would win the case in The Hague. And I'm constrained because the orders imposed on witness K and I by Christian Porter have not been lifted by the Albanese government. And I'm constrained in what I can say. Other than that, there is a deliberate posturing by the intelligence services to suggest that they're neither confirm nor deny procedure, which has legitimacy when there's a a genuine, legitimate operation underway, has legitimacy in relation to the alleged espionage in Delhi. It could never have that. It was never a lawful activity in Australian law. It breached the law, and of course that's what the 1688 Bill of Rights laid down, and that section of that bill is still the law in this country.
So then for 4 years, much of the prosecution ran behind closed doors. What is it like to face a court the public cannot enter?
I'll always remember the day it started. My Pollyanna had our little then 4-year-old on the knee, and they closed the court. They took the phones and watches off everyone who'd come in. They all had to trail out and get their phones and watches back. There was just me on the left-hand side of the court. Then there was the runners and bag handlers for the agencies on the right-hand side. It was a sort of like a shotgun wedding with me, the bridegroom, Shanghai, dragged in, and but what I'd never seen, and I've done many trials, many trials, many emotional trials, murder trials, and so on. I'd never seen ladders brought in and duct tape put over all the state of the art. This was a brand new courthouse in Canberra. Duct taped the cameras. The court recording staff were expelled, and people came in with black boxes to record it for themselves. This was insidious. It wasn't going well. It got a lot worse into the 4 years. Within a year or two, the mood in Australia was clear that the trial and attempt to jail me did not have popular appeal anywhere. Anywhere. There were constant demonstrations outside the court. And then, there was a particular High Court case that was very ominous in that I had asked for a jury. That was my constitutional right because I was charged with a federal offence, an indictable offence. But there was commentary in the court, I won't go into it, that indicated that a future government could restrict the right to jury further. The wording of Section 80 in the Constitution could allow that. It's allowed majority verdicts, for instance, and other things. And as this prosecution became more and more unpopular, I became anxious that the government, this corrupt government that was then in power, the Morrison government, would amend the rules to deprive me of a jury. The 4 years were all what we call interlocutory argument. We spent 4 years fighting this evil national security legislation that had been brought in. I had to give notice of who my witnesses would be, what their evidence would be in advance. In advance. And worst of all, the court had to accept the attorney's opinion of what was in the national interest. Court had to accept it. And further, the Commonwealth, the Morrison government's lawyers, said they had a secret document for the judge that no one was to see. So your history students would remember the secret cachet the French used during the prosecutions after the Revolution, and the British used in the Star Chamber. The secret cachet that went to the panel to convict whoever was on trial. So Morrison government offered a secret document in my trial. Now, I've done innumerable trials. I've never seen anything like it. And that was straight out of Orwell's 1984. It was astounding. And we had a duct tape court. We had the court reporting staff excluded. My own partner and child weren't allowed in the courtroom. It was a secret trial, belonged in wherever it is, secret Pol Pot, Soviet Union. And there was this ominous realization that we all have now that jury trial is not so guaranteed. There's a possibility that another government like the Morrison government, when they start an unhappy prosecution, might want to get rid of the jury. I was pretty sure a jury would acquit me straight off. But without a jury and a secret cachet and a judge directed to give the preference to the attorney's word, I wasn't sure where I'd be.
Hard to see the individualised justice in that. Witness Kate pled guilty, you refuse. Why did that distinction matter to you?
Well, I was pretty well known, I did part of the Iraq War inquiry as a barrister in the UK. That was well publicised. Anyone who wanted to hunt me down could find me. You got to remember that the Australian government went to The Hague, and I had this wonderful crew of young Australian women lawyers, one of whom was 7 months pregnant when the Australian government stood up in The Hague and accused us of espionage and alleged we'd put Australian lives at risk. At that stage, it was our lives became at risk because we got all the usual nutter, extreme right-wing fanatical threats to me and my staff. So I wasn't worried. But you've got to think about what if the Morrison government leaked Kay's identity? I'm going to leave your listeners and watchers to decide why Kay might have pled guilty. But, that face, those kids and grandkids, think of it. My team, we took the risk, but there'd be a much more fanatical reaction to Kay were his identity known. So we had to work so hard to protect that courageous, brave Australian.
The charges were dropped. Sorry.
Beg your pardon?
Oh, sorry. The charges were then dropped in 2022, but no one has been held to account for what was done to Timor-Leste. What would justice actually look like if it was served?
Well, the first thing you should know is that I spent years and years working with the leadership in Timor. I lived and slept, not in a biblical sense, with Chinana Guzmao all around the island, all those years. Immediately news of this broke, the whole region sat up. The Solomons, Vanuatu, Tonga, Fiji. Fiji had sent troops for Interfet in East Timor. It was such a disgraceful news. It did enormous damage. Australia's treatment of the Timorese did enormous damage in the region. It had already done a lot of damage before Australia assisted with Interfet. And then when it squeezed the Timorese over the petroleum issues, the region noticed. Everyone noticed. And to cap it, that Australia would do what it did, allegedly did a lot of damage to us in the region. This was a government that kept telling the new Timorese government to be careful of China. Well, what did we do? We showed what we think of an impoverished nation. We try and rip them off. And so our reputation in PNG and in our Indo-Pacific region, especially in Indonesia, when I was up in Jakarta with the leadership as well for negotiations, our reputation went to rock bottom. Not because of Witness K, but because everyone knew they'd been dudded. Everyone knew they were getting a minor proportion of the resources. So, what has been the outcome? Until Australia apologises, until Australia tells our Five Eyes partners that they will never, ever again allow maverick activity, we will be distrusted both in the region and by our intelligence allies. And that's something that Labor and Liberal have continued to cover up on. The best thing that should have been done was to congratulate Witness K, to hold those responsible, to tell the region we won't allow this to happen, and to tell our Five Eyes allies, who I greatly respect, that we will control our own and discipline them. Instead, we did the usual corrupt cover-up.
So then in 2025, a Senate inquiry again declined to deliver any real whistleblower protection. What would you say to the next person who's thinking about speaking up or speaking out?
Be strong. Be strong. You have to be strong. You'll be probably impoverished. Protect your assets and transfer what you can, and rely on all those great pro bono lawyers out there. Can you imagine if the government spent whatever it was, $6 and $7 million prosecuting me? Imagine what that law firm, Gilbert and Tobin in Sydney, and all the barristers spent defending me for 4.5 years. And you've got to give it to a lot of eminent people. Admiral Chris Barry, former Chief of the Defence Force, came and gave evidence for me. Gareth Evans, my old sparring partner over Timor negotiations, we made up and he came along and gave evidence, as did marvellous former ambassador in Jakarta and Washington, John McCarthy, and numerous others came and gave evidence. The public, I think the Australian public are ready to deal much more affirmatively with maverick and corrupt conduct in future. The NAC has been a failure, unfortunately, but I was very hopeful that Major General Brereton would investigate the alleged Dili espionage, but he didn't take any interest in it. I might say that Katie Gallagher promised just before the May 22 federal election that Labor in government would investigate prosecution of Witness K and myself and the alleged Dili espionage. That has not yet happened. That was an election promise in the Parliament. So whistleblowing is definitely highly risky. Now, when families can become victims, one has to be quite careful. And I'm not a lawyer that encourages imprudent whistleblowing. There have to be arrangements made.
To our audience, I've got one or two questions left for Bernard, and thank you for everyone who's sharing their comments and questions already. But if you do have one that you'd like to direct to us, feel free to use the Q&A function. Bernard, last question from me is, what do you most want Australians to understand about what was done to Timor-Leste?
That we're living in this region, that Timor might have been small bickies, small country, but the whole region has been watching Australia over the past 50 years, and our attitude to the region has been moulded to a great extent on issues such as genuine foreign aid, not checkbook diplomacy we're watching at the moment. These alleged defence treaties, I mean, they're all accompanied with a checkbook. A genuine treaty is a mutuality of self-protection, friendship, our visa rules, the cost of our education visas for the islanders, the Pacific Islanders, particularly the Timorese, is not good. And aspects of our Pacific Islanders labour mobility scheme, the PALM scheme, are not doing us much good. The German government showed how to use guest workers and how to let them settle in their country. We're not doing that. We've not got proper, broad, holistic policies to deal with our region. Timor was just a litmus test of that, and we failed it. We became opportunists. I think Timor has shown the bad side of Australia. The sickening thing was that I was so proud of our interfet men and women soldiers in Timor, so proud of it. And to think that while they were doing that, suffering the mosquitoes, the sweat, the risks, there was a slimy group planning something else that was undoing the reputational work our armed services did. I'm so very upset about the secrecy within the Howard cabinet. That is, that even our defence people were unaware of what was going on. There was no sharing there. This was a cabal, and the region knew it. The region knew it, and we cut down foreign aid, and the Pacific has been our area since World War II. The United States left it to us largely to manage the Indo-Pacific region, and we deserted them. So now we're paying the price, but we're using checkbooks to try and buy the affection we had been earning and that we lost.
We have our first question from, our first comment from Tamara, who says, we are watching this from the remote village of Soibada in Timor-Leste. Thank you, Bernard, for all that you have done for this beautiful country. Australia is a long way from paying our debt off to the Timorese. Thank you very much for sharing, Tamara.
Obrigado.
We have a question from Judith, who says, do you mean the Bill of Rights in the ACT? That was with regards to a comment that you had before.
Yes, the Bill of Rights, those provisions that I speak of, that no one's above the law, is on the statute book in the ACT, I assure you.
And Emma asks, what would it take for the Albanese government to lift Christian Porter's restrictions on what you can say?
I think that for the government to lift what I could say requires it first to make a cabinet decision about coming clean, apologising to the Timorese and explaining what happened to the region and commencing prosecution action against those party to the multi-million loss of revenue to Australia and the Timorese.
And we have a comment from Emma who says, I was part of the many demonstrations in Dili in 2004 and 2005 against the Australian government stealing Timor's oil. Biggest thanks to you, Bernard, for all that you have done. We also have a question from Renee, who says, when politicians are now asked for their view on whether the prosecution of Witness K was lawful or moral and whether the Timorese were treated unfairly or illegally by our government, they say they cannot confirm on matters of national security. How can they justify that?
Well, I keep saying it was not national security. If the alleged espionage took place, it was completely contrary to law. It was unlawful. Our intelligence services and in only highly restricted manners can act unlawfully abroad, but no cabinet can deliberately introduce a bill to Parliament promising to negotiate in good faith and then breach the same bill, which is what the Howard government did.
We have a question from Peter about Witness K, asking, is Witness K still incarcerated? And if so, how long before he gets out?
Witness K got his passport back from Penny Wong a couple of years ago and is no longer effectively in house arrest.
Thank you. And a question here, Bernard, do you think it's time for a Human Rights Act in Australia?
Absolutely. Of course we need it. We need the rule of law more actively enshrined. We need to stop governments trying to politically outplay the High Court, the way they've been doing it over indefinite detention issues and that. The lack of respect by the executive often towards our federal and High Court decisions is ominous and has shades of Trumpianness to it. You've got to be active in the legal scene to know what I'm saying, but Greg Barnes, of course, who can't get on tonight, I think he'd be nodding were he on screen.
A comment from Russe says, you inspire me, Bernard, and George comments, thank you for this informative presentation and discussion. I knew a fair bit of the history, but Bernard has provided so much broader context and useful information. Peter asks, the renegotiation of the Timor-Leste agreement forced by the revelations that yourself and Witness K improved the treaty, but are arguably still unfair and do not include return of resources unfairly taken from the Timorese. Is there a case for a campaign by the Australian to recompense the Timorese along with an apology from Parliament?
Yes to the apology, but there is no statute of limitations in this country, broadly speaking, in respect of criminal offences. The fraudulent activity towards both Australia and Timor-Leste, I emphasise, we couldn't even steal efficiently. Most of the ill-gotten gain went off to international petroleum investors. The fraud was both on the Australian Treasury and on Timor-Leste. I emphasise, multi-millions was lost to Australia and Timor-Leste out of this cooked up deal. And I'm talking about the negotiations. So really, a reparations claim is not out of the order. A reparations claim on behalf of the Timorese and action against the international petroleum companies that shared the loot, Neverna.
And of course, if anyone would like to read more about this, you have wrote a book, Oil Under Troubled Water, Australia's Timor-Leste Intrigue. I've got one sitting at my desk at work. But if anyone else would like that, I've left a copy of it in the chat.
There's another one.
There's another one.
Sequel. Well, of course, as you know, the government found out about the book and tried and wrote and threatened prosecution. But full marks to Melbourne Uni Press, full marks to Liberal Democracy as it then stood there, and they went ahead and published, and it wasn't pulped. But there's another manuscript with Melbourne Uni Press now, and it's a lot hotter than the first one.
I look forward to it. Lenore says, thank you very much, Bernard, for your integrity and courage and trying to stand for what is right. Perhaps before we wrap up very soon, if there's any further questions, there's one last here from Claire B. Multi-billionaires are still being lost by Australians to the carpet-bagging fossil fuel overseas campaign. Our government won't even tax our own gas. That is from Claire B.
Well, the Australia Institute's done a lot of work on that area, the gas. They've just ripped us off like, the 19th century colonial exploitation. The petroleum industry people have just taken the money.
And Bernard, that brings us to the end of our questions. On behalf of the Information Rights Project, we want to thank you so much for sharing your stories, your time and yourself with us tonight. We have so many more comments and thank yous coming in from George and Jan. So thank you again, Bernard, and to everyone who's joined us. Thank you so much for your engagements, your comments, and for sharing your evening with us and for standing with whistleblowers all over. Thank you and good night.